Afternoon. Good afternoon. It's a busy day, a lot of committees going on, a lot of bills being presented by members of this committee, so we're going to try to go ahead and get started. There is a sign-up sheet. We've got two bills on the agenda, Senate Bill 186 and Senate Bill 142. If you want to speak to either of those, for or against either of those, please put it on the sign-up sheet and indicate whether you're for or against, if you would, please. And I will take that up shortly and decide how much time to allocate to each side. Let's open in a word of prayer. Senator Kirkpatrick, do you mind to give us a word, please? 11.
Dear Heavenly Father, thank you for another beautiful day in Georgia, and help us to remember the people that we serve in all the things that we do, and to follow our state motto of providing wisdom, justice, moderation, and courage. In your Son's name, amen.
Thank you. All right. Let the record, so I'm going to let the record reflect we have a quorum, and I'm going to call the meeting to order. First on the agenda, Senate Bill 186, Senator Dolezal, Georgia Landowners Protection Act. And give us your LC number, please.
Thank you, Mr. Chairman, members of the committee. I'm working off of LC 442762S.
I'm sorry, I didn't have you on. Repeat that, please. Sorry.
Sure, LC 442762S.
Okay.
And Mr. Chairman, if it's okay with you, I'd like to have Megan Hansen join me with Georgians for Lawsuit Reform.
Yes, sir.
She, along with a number of other folks, have been working on this language. It looks familiar to the committee, I hope, because this committee passed this bill last year. And there's really one significant change that I'll point out to you. But this legislation, as you recall, revises Georgia's premises liability laws, following on a number of appellate decisions that highlighted inequities and inconsistencies in Georgia law. In fact, if you remember last year, the Georgia Supreme Court actually identified the need for clarity surrounding these issues in the code, and the clarity is exactly what we hope to bring today. Due to the erosion of premises liability laws over the last 5 to 10 years, Georgia now has one of the most liberal premises liability laws in the nation, more liberal than California and significantly more liberal than traditionally plaintiff bar-friendly Mississippi. Current premises liability laws force our courts to operate on a case-by-case basis, which leads to unpredictable application of the law and uncertainty in verdicts. There is presently no clear, bright line for what landowners can or should do in order to protect themselves against premises liability claims. And we have seen that even prudent landowners are getting popped with multi-million-dollar verdicts. As the courts have made clear, this ball squarely falls in our court. Because this committee passed the original bill of 186 out last year, Mr. Chairman, I'm just going to touch on what changed. And we clearly provide definitions, parameters for who a landowner is, what exactly qualifies as property, and defines what a premises liability is in the statute. The one change that I want to highlight for you came from feedback from this committee last year, as found in lines 22 to 24. And it specifically excludes this law in any way being used as a defense for those who may participate in sex trafficking and human trafficking. So we spell out the code sections here for that. And really, Mr. Chairman, one of the most important aspects of this legislation is landowners are only responsible for acts that occur on their own premises. This clarification is stemming from a case where a landowner or business was held liable for violence that did not occur on their premises and while the business was closed. So with that, I'm happy to answer any questions. I know there are folks here from both sides of this issue that would like to be heard, so I'll keep my testimony brief and get out of the way and let the committee hear from them as well.
Any questions for the author? All right.
Chairman Dolezal, thank you for coming with this bill, and thank you, Megan, for all your hard work and the people in the room that have been advocating for this for many years. Can you tell me the definition of trespasser as it relates to this bill? Is it defined elsewhere in the code?
I'll point Megan to that too.
Is this on? Yes. So it is not defined in here, but it is defined elsewhere in the code. I do not have the actual legal definition on me right now, but I have it in my bag, so I can give it to you in a few
I'm
minutes.
just wondering if you could paraphrase, is it anyone who's uninvited?
Who is basically who's not only invited, but is there with kind of criminal activity. They're looking
Correct.
to do something
Okay.
bad.
So how would this bill protect farmers and people out? It's not a commercial type property. I get the whole retail establishment, but talk about how this might help people out in rural Georgia and farmlands and people with big tracts
Sure.
of property.
I think, Mr. Leader, it might be helpful to refresh everyone's memory that we really define 3 separate standards of care in this bill based on what type of person is causing the issue on the property. Starting on line 29, you'll see the standard of care that needs to be provided for an invitee. And an invitee, in the case of a farmer, would be someone who is there to do business with a farmer if they're holding a farmer's market, as an example. Starting on lines 42 to 51, we talk about a licensee. And a licensee is someone who has permission to be on the property, but may not be doing business on the property. So that might be somebody who is staying overnight on a landowner's property at a Walmart. Think about a trucker who's staying overnight. We could think of cases where that would apply to farmers as well. And then lastly, what we just talked about starts on line 52. We have the standards of care that are required for the trespasser. So in thinking about what might be the case for a farmer, you may have 2 workers who are in a field on any given day that have an altercation, and one pulls out a gun and shoots the other one. And based on under what circumstances they were there, this law would define the liability of the landowner. Right now, we kind of have this open question as to what you as a landowner are responsible for when it comes to someone else's activity on your property. So what we're trying to do is to clearly define what it is that you as a landowner are responsible for when something happens on your property, perhaps something that you don't even know about, or someone that you don't even know about. And that would be in the case of the trespasser. that
So
you asked
without
about.
passing this law, under current law today, a landowner, a property owner could be held liable in a courtroom without any involvement of a crime or any occurrence of anything that they had involvement with. Is that what you're saying?
Yes, and that's actually occurring. And even when in circumstances where, for example, the landowner will tell the person who has requested permission, no, you are not permitted to come on the land, and then they still do, and then there's an accident, the premises owner is held responsible.
Thank you.
Thank you. Chairman Dozal, you said something a few minutes ago about a trucker parking on a Walmart parking lot. And I know in many cases, personally, I haven't parked in a Walmart parking lot since 1999. So, but do they promote truck parking in their parking lot after hours when the store's closed?
I could actually refer you to yes, or they will give permission. As you know, I spent 10 years in the music business, and we had a particular Walmart that we would meet in their parking lot to get on our bus before we would head out on tour. The Walmart was aware that we were there. They gave us permission to do so, but we would not always or even not often go into the Walmart to buy anything, but we had their permission to use their premises.
So do they accept any liability under this if something were to happen in that parking lot with loading equipment, doing something else? So a member of your entourage would be injured. Would Walmart possibly be liable for any injuries in that situation?
Well, first, Senator Robertson, I would assume that's probably no longer like a thing that they really do.
Well, let's don't assume. Let's
Well,
do it under the role that Chairman Dozal and I are talking about.
Sure.
To where the Walmart has an understanding with a group that they can use their parking lot for offloading, unloading, things of that nature.
Sure. I would venture to guess that those are probably not necessarily premises liability claims, because you're not using the property necessarily for how they intended. But I mean, that's a kind of, it sounds like a borderline contract between the person who's asking for permission and Walmart. And so I can't speak to kind of what the arrangements were, particularly with those two groups.
So if I boil that down, you don't know. And I'm not trying to be mean or anything.
And
This
I
is one of those things, as our friends across the way have talked about, something that we've worked on extremely hard through the years. And I want to make sure we're very clear on this, that if I enter into a contract with Walmart, written or handshake, then is there the possibility that if I'm injured, they could be, I possibly could have a case?
The terms of the contract would dictate that.
Okay, thank you. Now, if I had no understanding with Walmart and I went there on my own and I parked my truck overnight, or I told all my buddies to meet me there, we were going to load and unload and do all this other kind of stuff, and I become injured or something other bad happens, then do you feel that Walmart under this law would carry any liability for my injuries?
You would be considered a licensee status, and so the obligation that would be owed to you would be set forth in this bill.
Okay, so in other words, because I was using their property without any explicit permission to do something for what the property was not intended for, which it's intended for people to park and go inside and do business in their store, then I'd have an uphill climb under this legislation. Would that be correct?
Correct.
Okay, thank you.
All right, so I have a question. Does this bill, how does it impact the attractive nuisance doctrine? Let's say I'm a homeowner, I've got a swimming pool, it's not fenced, I've got neighbors in close proximity to me, I'm in a subdivision, a child drowns in my pool, one of the neighbor's children. How would this impact, how would the changes that you're proposing impact that case?
I would need to do a line by line of that doctrine and compare it to this, but I would, from what you're describing, I would assume that the child or the neighbor is an invitee, and that means that the landowner has the highest duty of care to that family, to the child, to be protecting their premises.
Well, they weren't invited, but it's a child that just wanders over there. I don't know what the legal term invitee
So
means.
there are different standards for children, so I think that would apply here. And again, we take extra care when it applies to children.
Okay.
Mr. Chairman, I would also point you and Whip Robertson to, under each one of these sections that I talked to you about, whether it's invitee, licensee, or trespasser, I'll just read this one to you as it relates to licensee. No landowner shall be held liable in a premises liability action to any licensee who is injured on the landowner's property as a result of the willful, wanton, or intentional tortious conduct of any third party. And I think that third party is the trigger in every one of these that we need to remember. So what this bill is targeting is when a third party commits an act on a piece of property. That's the types of cases that we're talking about. So we're not talking about a slip and fall case.
That's a great clarification.
Yeah.
That's in every section?
Yes,
It
sir.
is.
Okay. Well, I'm glad we got to that. I could have read the bill more thoroughly, I'm sure. So we have, so you and several others. Senator Harbin, my vice chair.
Yeah, sure. Just one question. I know that on farms especially, agritourism is a really big part of what's going on for a lot of farmers and things of this nature. Does this have anything specifically to help them anywhere in there that would help in the tourism area? Because I've had questions and clients as well.
It definitely protects them, I would say, but they also have their own bill or their own statute, as my understanding, for their premises specifically for agritourism.
Okay.
Yeah, we
Thank
passed
you.
something out of, I think, the Ag Committee related to that several years ago.
Okay, good. Okay, thank you.
All right. Senator Merritt.
Thank you, Mr. Chairman. My concern here is that this bill would actually disincentivize property owners from providing safety measures. So what safeguard do we have in this bill that this isn't doing, is actually doing that, disincentivizing them, because we're trying to loosen their liability?
We're trying to provide, Senator, I would ask you maybe to clarify what you think loosens this specifically. But we are trying to clarify when a landowner is and is not responsible for something that a third party does on their property. So it's not that we're looking to disincentivize them from providing security. In fact, if you look, we do have a number of things that are triggers in here and tests in here for the courts to determine what that liability would be. But largely what we're saying, if I were to put it into a loose bucket, is that if you're a business owner, somebody comes into your parking lot and shoots someone and you didn't know that they were there, that is not your fault as a landowner. And these are the types of cases that we've seen, and that's a broad brush to paint with. But I think that you and I could both agree that there are things that landowners need to do to provide a safe environment, but there are also things that can happen on someone's property that's completely outside of their control, that it is unreasonable to hold them liable for that. And so what this bill does is it recognizes that there's different types of people who will come onto property, people that you know, people that you do not know, and provides the standard of care there for what you're supposed to do. So what I would say, actually what this bill does, rather than loosen it, is it actually provides some clear lines as to what it is that they have to do to protect people who are on their property.
I would also add that you're about to hear from a number of business associations, and those people want people coming to their business. So if your business is deemed unsafe or it's shady or whatever, and customers don't feel comfortable going there, that in and of itself is going to hurt your business. So I would think that there would definitely be the incentive to bring customers there and make it a safe premises to do just that. You just don't want to get popped with a $75 million verdict because something happened 9 miles away, and in your case, you're being held responsible for the crime that happened in the neighborhood as opposed to on your premises.
I'm going to allow one more question. Senator Cowser.
Thank you, Mr. Chairman. It's just two quick ones if I can. There are several places, line 36, 48, and 58, where you use the term impelled the specific action. I'm just not familiar with that term, impelled. Give me a synonym for that. What does that mean, to impel?
It's my understanding it's like borderline compelled. You made it happen. It was your fault. That type of thing.
Like compel. The second is that under the invitee section, starting at line 29, down on 37 to 39, you have a subparagraph B, that the landowner had actual knowledge of it. You don't include that same language under a licensee or a trespasser, and I wondered why, since under property law you have a lesser duty to licensees and trespassers than you would to an invitee. Why don't we require a landowner to have actual knowledge of the specific threat for licensees and trespassers as we do in this bill for invitees?
You want to take that?
Yep. I would say because they also have to take the next step, and that is to prevent the harm from happening. So you not only have to know about it, but then you have to actively prevent it, and that's part of the duty to invitees, which you don't have to know about it or prevent it to the duty for licensee and trespassing.
So it makes it easier for a trespasser or a licensee to recover than it does for a business invitee, a customer. That doesn't make sense.
I'm not sure I 100% agree with you there.
Okay. All right.
Mr. Chairman, I would say that it's not that the trespasser or a licensee are collecting. It's the act of them that somebody else would be trying to collect for. Does that make sense? So somebody being inside of a grocery store shopping,
Right.
the expectation there would be, if they were to pull out a gun and shoot someone, would be different from the expectation in terms of liability if somebody were to be in a parking lot, using the parking lot for a Facebook marketplace transaction.
But the property owner would ordinarily have a higher duty to protect their customers in the store than they would a trespasser in the parking lot. And this lessens the duty because they don't have to have actual knowledge of the problem for a trespasser, but they do have to have that for the invitee. I just don't know why we wouldn't use that same language for all of them, but it's okay. I supported your bill last year and I support it this year. I think it's even better.
Thank you. Google says that impel is to drive, force, or urge someone to do something. So it almost sounds like collusion, or they're participating with the third party. So I think that's an exception if the property owner is colluding with the third party to do this tortious act or whatever, maybe that's what that's getting at. Does that sound right?
Sounds right.
Okay. We've got 6 people to signed up for the bill and 2 want to speak against the bill. I'm going to allow 8 minutes per side. You all decide. I imagine the 6 people, a lot of them are going to say the same thing. You can just, if you want to, just come say we oppose the bill, but figure out who's going to be your main couple spokespeople to get into the legalities of the bill, if you would. And then on the same amount of time, 8 minutes for those that are against the bill, and it's only 2 against. I'm going to let the opposing people speak first so that the other 6 can decide who's going to be their longer spokesperson. So I will call up Mike Moran and Dan Snipes. If y'all want to come together, you can, or separately. When they start, we'll start the clock. Good to see you all.
Good to see you,
See you, Mr. Chairman. You go first. Thank you, Mr. Chairman.
Introduce yourself for the record and who you're representing, who you're with, and then I'll start the timer after you do that, okay?
Thank you, Mr. Chairman. My name is Mike Moran. I'm a lawyer here in Atlanta. I'm here with Dan Snipes, and we're here to we're in opposition of the bill. A little bit of background on me. I was born and raised in Jessup. I've been practicing law here in Atlanta for 26 years, and for the bulk of that time, I've been practicing extensively in the area of premises liability, as well as negligent security, which is kind of a type of premises liability law. And that's really what this bill is about. It's really the negligent security component of premises liability law. And I heard, I think it was Senator Dolezal was talking about one of the reasons that they put forth this bill is to clarify the law in this area. And it does clarify it, and I'm not saying this being a smart aleck in any way, but it does clarify it because the effect of this bill would be that there would be no negligent security claims in Georgia. There would be no practical way to prevail in one of these. And I'll explain why. If you look at the bill, starting at line 35, which is where really the elements that the plaintiff would have to prove in order to succeed in a claim when somebody who lives in an apartment or a customer on a business is the victim of a crime from a third party, here's what you would have to prove. And starting at line 35, line 33, you'd have to prove that it happened on the property. Line 35 says, also you would have to show the conduct of the landowner actively and affirmatively, and with a degree of conscious decision-making. So that means there's kind of an intentional component to it, that the property owner or the business owner was making a conscious decision to impel the specific action of the third party. And Mr. Chairman, you just read the definition of impelled, which is to drive or force. So you would have to show that the business owner formed a conscious decision to drive or force this third party criminal to commit the crime. I can't conceive of when that would happen, that basically the property owner and the criminal would be in some sort of collusion, as you said, or conspiracy to commit the crime. There's a second way you can prove it, and that's this subsection 2B. The landowner had actual knowledge, I think we all know what that means, you actually knew, of the specific threat of imminent harm. So whatever the customer or the person who lives at the apartment complex, the crime that was committed against them, the plaintiff would have to prove the property owner had actual knowledge of that threat. So let's say it's a murder or robbery. Would have to have actual knowledge of that threatened murder or robbery, but of imminent harm too. We all know what imminent means. That means immediate. That's in the Black's Law Dictionary. We know that one. Senator Calcert talked about impelled. It's not a term we're familiar with in Georgia law, but imminent is. And that means immediate. So you'd have to show that the property owner, the business owner had actual knowledge of that specific threat that this customer was about to receive of imminent harm. And
was through reasonable action was able to prevent it. So it has to be imminent. So I'm pumping gas at a gas station, or I'm walking up to a Kroger and somebody holds me up. The manager, the property owner, would have to know of that specific threat right then, and it would have to be imminent, so not a plan to shoot me, and they would have to, through reasonable action, be able to prevent it. Well, what would the reasonable action be? Unless somebody was, a security guard or somebody was carrying a gun and was able to shoot the perpetrator right then. So the reality of it is that these elements could never be satisfied under any real-world event. And as an example of the type of things that this bill would allow, and to Senator Merritt's concern, and really encourage by allowing it, because we all know that's how tort law works. We're encouraging and discouraging societal behavior. And so this would encourage this kind of behavior. Let's say an apartment complex has actual knowledge that there's a known sex offender, somebody who has committed a sex crime before. Let's say they know that. And this person is wandering around the apartment complex for days and is threatening minor girls or menacing to them, let's say, saying things like, "You should be my girlfriend," or "God forbid, you look sexy," or something like that, that everybody knows is menacing coming from a child predator. If the apartment complex knew that and it had been reported, and just allowed this predator to roam the property for days and did nothing about it, and a child, God forbid, was raped, there'd be no claim under this statute for the reasons I just went through, because you couldn't prove that the apartment complex owner, with a degree of conscious decision-making, impelled that conduct, because they didn't force that to happen or nudge that to happen. They just negligently did nothing and allowed it to happen. And as I mentioned, the only other way to get there is actual knowledge of the specific threat of imminent harm. Well, there's no threat of imminent harm if a sex predator is making menacing comments like, "You should be my girlfriend," or "You should be sexy." That's not, I'm about to do something. That is not imminent harm. So this poor child would not be able to bring a claim for that kind of activity, and that would encourage reckless conduct by apartment complexes. As another example, that's not just a hypothetical, this is a real-world case that we did last year against an apartment complex. And in these cases, as those of you who are lawyers know, Senator Calvert knows this well, and any of you that might have studied this, one of the things we do in these cases, we always look at the criminal history. We get the police reports to see what's going on this property. This particular apartment complex, in a 2-year period before our client's injury, there were 18 shootings, 5 robberies, 9 burglaries, and 8 aggravated assaults. My client, a mom, was living in this apartment complex with her children, including a 15-year-old daughter. She was frightened living in this. The lock on their window, on the child's bedroom window, did not work. The mom had reported it repeatedly to the manager, the property manager. "Please come fix this window." They wouldn't do it. Just fix a lock on a window. How much does that cost? $5, $10 tops? Wouldn't do it. And a rapist climbed in the window one night and raped this 15-year-old child. For the reasons that I have gone through twice, you could not prevail in that claim against the apartment complex, even under those facts, given this bill that's being presented to this committee today. This is bad policy for Georgia. It would encourage this type of behavior. We should not encourage this type of behavior. We should discourage this type of behavior. So we would ask this committee, or I would ask this committee, I think Mr. Snipes wants to speak to not pass this bill.
Thank you, Mike. I'm Dan Snipes. I'm an attorney in Statesboro, and I represent the Georgia Trial Lawyers Association. As Mike pointed out, this bill, within the confines of premises liability cases, addresses negligent security. In the CVS v. Carmichael case, the Supreme Court did say we're not in a position to change the law. Our job is to apply the existing law. And case law in Georgia over the last, really since 2005 is when this area of negligent security cases has developed. Case law in Georgia is what CVS v. Carmichael was decided. But what the Supreme Court did not say, you need to change the law. They just said, our job is not to change the law. So what the CVS v. Carmichael case was, taking existing Georgia law and saying this is in one place what the standard is for negligent security cases. My comments are really for the non-lawyers because Senator Calvert and Senator Kennedy, a bit backwards there, but they both know that personal injury cases based on the negligence of another, tort cases, okay, they're based on the breach of a duty, all right? And the duty that you owe to someone in certain circumstances. And what this statute does is tell landowners or occupiers of land, meaning the people that lease the building, that run the business, that you do not owe a duty to people to protect them from the harm of another, from the crime of another, regardless of how much knowledge you have about it, unless you either instigate it, that's what impel means, unless you instigate it, or you know it's about to happen and you could reasonably stop it. But it takes the definition of duty and it shrinks it down so small that it does exactly what Senator Merritt said. It takes away any incentive to ever make your property safe, whether it's a business that's inviting people on their property to do business, whether it's a licensee. And I like to think about licensee this way.
Commissioner,
Yeah,
wrap it up if you don't
Real
mind,
quick.
Commissioner.
real quick. A licensee, I grew up in Dublin. In Dublin, the McDonald's on I-16. That's where parents met to swap, divorced parents met to swap kids on Sunday. And I'm talking about hundreds of them did it. And the parking lot of that McDonald's, if a single mom's picking up her 2 kids and she don't want to go buy a hamburger, but she's meeting her ex-husband there, she's a licensee. And if McDonald's knows they've got a crime going on in that parking lot, they should have a duty to protect that single mom. And this bill totally does away with that duty, and that's the reason it's bad legislation. Thank you.
Thank you. They all did good, staying within the time constraint. All right, I'm gonna read the list of people that are for this legislation in case they may not want to come forward and say it. It'll be in the record. Will Barnett, Georgians for Lawsuit Reform is for. Laurel Hart, Columbia Residential is in favor. Hunter Loggins with NFIB is in favor. Kathy Kazava with the Georgia Food Association is in favor. Nancy Palmer with the Georgia Chambers in favor, and Jeff Ledford with the Georgia Realtors is in favor. Who would like to come speak for this group?
Will Barnett for Georgians for Lawsuit.
All right.
First two, Mr. Chairman?
Yes. I got it.
I don't need to, I'm low.
I will aim to be brief. Good afternoon, Mr. Chairman, members of the committee. My name is Will Barnett. I am here in my capacity as chairman of the Georgians for Lawsuit Reform. GLR represents a broad and diverse range of industry and commerce in Georgia, with many national members as well. Was founded by active members of the Georgia business community to be an advocate for a more fair, balanced, and efficient legal climate for all Georgia citizens. As part of its efforts, GLR seeks to educate the General Assembly and the public about the impact that our civil justice system in Georgia has on the economy and business development in our state. I'm here to speak in support of Senate Bill 186. While we are thankful to this committee for moving the bill out last year following the Supreme Court's decision in the CVS litigation, which has been referenced earlier, really came to the conclusion that our premises liability laws were even weaker than we thought and provided less protection for the business community. We support this bill to provide much needed clarity for the business community and landowners in general as to what our obligations are to invitees, licensees, and even trespassers. This bill strikes the appropriate balance in what landowners should be responsible for securing, such as their own premises, while not penalizing them for what happens on other premises that they couldn't possibly be responsible for. Again, Georgians for Lawsuit Reform fully supports this legislation and thanks Chairman Dolezal for his hard work on the subject matter that is very important to the business community. The last thing I would say, in response to the parade of horribles we heard before, this bill just tries to strike a balance back to fairness. The CVS outcome that revealed the state of Georgia law presently really makes it very hard for a business to escape liability in these third-party criminal actions. It's an intervening criminal act. Business owner can't stop it from happening, yet they're still liable. So that's why we think this bill is a big step forward in the right direction of just restoring balance to the civil justice system in this state.
Thank you,
Happy to answer
Mr.
any
Barnett.
questions.
We have a letter in the file from Mr. Barnett also affirming his support of this legislation. We've got a letter in the file. I'll draw your attention from the National Federation of Independent Businesses in support of the legislation. I think next we're going to hear from Ms. Hart. Is that right? Okay.
Good afternoon, everybody. 2 minutes doesn't seem to be very long to talk about something that I think is the greatest threat to the affordability of many, many properties in Georgia. My name is Laurel Hart. For 20 years, I was the Director of Affordable Housing at the Georgia Department of Community Affairs. When I retired from public service, I joined the firm of Columbia Residential, which is a mission-oriented, affordable housing developer here in Atlanta. In 2019, one of the great takeaways between public service and private business is that the view from behind the desk is a whole lot different than the view in front of the desk, which is something that I have seen since I joined Columbia Residential. When I talk about a mission-oriented nonprofit developer, I'm telling you that we do security cameras, we do armed guards, we do crime letters, we collaborate. We have crime on our properties. Can't stop it. I listen here to foreseeability, understanding crime that's happening in the community. We do that. We can't stop it. We can have guards in the parking lot and crime still happen. What has happened as a result of the current premises liability laws is we can no longer obtain firearm coverage. We can no longer afford to manage our properties. And Columbia Residential, like many affordable housing developers, are going to be looking very carefully at why we are in this business. Mission-oriented means we go into the worst neighborhoods. We go into those where crime statistics are high. We demolish blight. We help the neighborhood. We work with local government, and we do everything to improve the lives of our tenant. When I came to Columbia in 2019, we had 25 million of excess insurance coverage. We felt that was necessary for us to be sustainable. The last 15 million of that coverage cost us $62,000. Last year in 2023, we paid $3.5 million for $2 million of coverage without firearm coverage. We are no longer insured at many of our properties because of the current liability laws. We support this move in the right direction when good businesses that care about their tenants, care about their customers, and care about their communities can no longer do business, can no longer get insurance. That is the point that the legislature needs to step in because the system is broken. And I hear the plaintiffs' counsels, and I'm actually supportive as a longtime insurance defense attorney who worked on both sides of the aisle. But I think if you ask them, they may not support this legislation, but I'm sure they support the ability for businesses to have insurance. So in the event somebody is injured, there can be a recovery.
Thank you, Ms. Hart. Good job. All right, Hunter, do you want to say anything?
It's all in the letter. Thank you, Mr. Chairman.
Thank you, Hunter. Kathy, you want to speak?
Yes, sir.
You got about,
Thank you, Mr. Chairman. I'll make this very, very short.
yes, ma'am.
Thank you so much. My name is Kathy Kazava. I'm the president of the Georgia Food Industry Association. I represent the supermarket industry across the state, from the smallest mom and pop IGA store to the largest Publix, Kroger's, Walmarts of the world. I would just like to say we are so thankful for all the leadership that you are providing in giving us some relief on premise liability. So many times, and I've told many of you this, when a legislator comes to the Capitol for the first time, they always ask me, can you please get a grocery store in my neighborhood? Everyone wants a grocery store. The problems that we are having, especially in our rural areas, or especially in the areas where the crime it happens. It happens all the time. We spend millions of dollars in trying to take care of our customers, take care of our employees, but the insurance and the premise liability is something that any leadership that you can give on this issue would certainly be appreciated. Thank you.
Thank you, Kathy. Thanks for looking after us every day here. All right, Nancy.
We've got a letter, so I think we're good.
Okay. All right, Jeff.
I need 30 seconds.
Yes, sir.
We are in support of the bill. We appreciate that property managers are protected in this. There's one, I think, unintended consequence that our general counsel just caught, and it's that it brings in agents of the owners. And we just want to clarify that that does not include real estate brokers that are listing property or showing property on behalf of another, and we can get that language if needed. But that's our only concern. Otherwise, we're in full support.
All right, Jeff. I would recommend you work with the author of the bill if you want to get
Absolutely,
that
yeah.
in there, because it's not now. Thank you.
I understand.
All right, that concludes the public testimony. I'm going to give Senator Dolezal an opportunity to close out.
Thank you, Mr. Chairman, members of the committee. I think we all go to the press conferences where the governor announces that Georgia is the #1 state to do business. I think we've lost count as to how many years that's the case. But we earned another distinction a couple years ago that we don't have a press conference about, that we don't really like to talk about. And that is we have also been named the #1 judicial hellhole in America. It's because of some of the cases that we've heard today are examples of areas where our civil justice environment have not become venues for true justice, as we would all probably equally want to define it, but that it has turned into jackpot justice. And this is one attempt to rein that in and put some guardrails around these cases and these nuclear verdicts that are driving insurance companies out of the state at a more rapid pace than I think that we're even able to count. I heard of 2 more carriers leaving the state just earlier today. Somebody told me that 2 carriers announced that they're leaving the state. We heard from Kathy, and I think it's very important to listen to her. I think all you know, I'm from Chicago, and I can pretty much enumerate everything that is wrong with that city as the direction that we don't want to go in. But Walmart closed half of their stores in Chicago just a couple of years ago because of the crime environment and because of the overall business environment. And we need to ensure that we don't have food deserts that continue to emerge in the state, in areas where business people look at the environment and say, I just don't want to do business there. So I would ask for your favorable consideration of this bill. Mr. Chairman, I would point out to you on line 83, there is a Scrivener's error that I would ask you guys to clean up on an amendment, if you will. There is a rogue quotation mark at the end of line 83 that would ask you to clean up. But certainly appreciate your consideration of this bill and your support of it in the past, and hopefully you've earned your support for it again today.
Any questions for the author?
A rogue quotation.
Yes, sir, Mr. Pro Tem.
Thank you, Mr. Chairman. I just had one real question for Chairman Dolezal. Chairman, a lot of the discussion that we've heard, either from the anecdotal stories of what has happened or the case law that is developed and the problems that we're trying to address, involve commerce or business. But as I read the bill, this doesn't just protect or give clarity to the duties that a business that happens to own real estate owes to different levels of people that come onto their property. Does this not also give that same clarity and protection to the average landowner, which can be somebody who owns a house, it can be a farmer who owns a little bit of acreage, it could be whatever. Is that correct?
That's correct, Mr. Pro Tem. If you look at lines 16 through 19, you'll see how we define landowner there, and it does get into owns, occupies, leases, operates, maintains, or manages any residential, agricultural, commercial, or other real property in the state. So I would agree with your assessment.
Thank you. Thank you, Mr. Chairman.
Yes, sir. Any other questions? Okay, what's the favor of the committee? Got a motion from Senator Cowser, do pass, second from Senator Kennedy. Any further discussion? Anybody want to offer an amendment?
What was the amendment needed on the broken quotation on line 8? Just remove that. So not to make a motion to remove that quotation on the
motion and a second to amend the bill to remove the quotation mark at the end of line 83. Any discussion? All in favor signify by raising your hand. Opposed, like sign. All right, we got 5-3 on the amendment. Amendment passes. Now we got a motion and a second on the table. All those in favor, raise your hand. Opposed, like sign. 5-3. Your bill passes.
Thank you, Mr.
Thank
Chairman.
you. Okay, next we've got. Going to bill and health in a few minutes. Senator Anderson, Senate Bill 142. This is a bill we started work on last year. You made a lot of changes. We got a committee substitute in the folder. Has to do with dangerous and classified dogs. LC 472921S. Is that correct?
Yes, sir.
Okay, y'all give Senator Anderson your attention, please.
All right. Thank you, Mr. Chairman. Thank you for allowing me to bring this bill back from last year. This bill it happened in my backyard, basically, right across the road. I had a child that got attacked by a dangerous, vicious dog Christmas. He was riding his bicycle in the neighborhood, and the dog attacked him, and also his brother was riding his bicycle too, and the grandmother had to come out and beat the dog off the child with his brand new bicycle. But that child stayed in the hospital for over two months recovering. But he's doing well now. But all this does, ladies and gentlemen, I love dogs. I got dogs. But all this bill does is if you own a dangerous, vicious dog, you take responsibility for him. And then also, it's on section 1, it's about, the responsibility of dog ownership. And then it also protects the working dogs and the hunting dogs, that they will not be in this classification. It also, we added some lines on 29 to 31 that where if a dog has been law enforcement or dog control have had 2 or more occasions about this animal within 12 months period, that they can go in and classify them as a dangerous, vicious dog. It also, on line 45, it protects all the law enforcement and military dogs, that K9 and all, that they don't fall in this category also. And then also 4950, it's basically saying that no particular breed is considered a dangerous, vicious dog. Any type dog could be one. Section 2 is the requirements of insurance. And make sure that you have secure on 65 through 66. You have a secure lock and enclosed pen and fence area for the dog, and also have signs saying that you have a dog behind that fence. Owner should have on line 70 at least $50,000 of liability insurance, and then also 73 and 74 provide sterilization and microchipping of the dog and the microchip number. And I don't know, Mr. Chairman, but it might be an area right there, because I don't think we have it in the bill, is if we could add a current rabies vaccination. But we'll come back to that. And then also, lines 107 to 110, it shows that any person that fails to comply, it can be up to $1,000 fine, no more than 12 months imprisonment. The Section 3 is the penalty for violation. Any person who, on 117 to 119, any person that fails to comply shall be, could be fined up to no more than $5,000. And that's basically the bill. But like I say, I don't believe in the bill we have nowhere about current rabies vaccination, and I would like to add that if I could.
Questions for the author?
And let me say that we have worked hard on this, and we got all sides have come together, sir.
Chairman Anderson.
Yes.
Can you tell me, in current law, do we require a court to declare a dog vicious or dangerous, or what determines that? If it's just somebody's word that it bit previously, or?
Well, you got the definitions of a dangerous, vicious dog.
Right, but it doesn't say.
I know who determines it.
Yeah, is it determined by a magistrate court or a probate court, or is it just somebody's word that?
Hold on just a second. Come, I got my backup unit here. State your name.
I'm sorry,
your name.
Claudine Wilkins, attorney. Yeah, my sole practitioner. Sole practitioner, Claudine Wilkins, PC. Right now, if someone's cited for a classification, the dog control officer can determine that the dog bit based through their investigation, and once they determine that, they send a letter to the owner. The owner has the right to appeal that, and it can be heard by a board if it's designated in the county, or it can be heard by the magistrate or whoever the county assigns that to. Some counties are so small that they don't have an actual board that meets, but some do, and they're dog advisory boards.
So is that already codified?
Yes,
Okay.
that's in the law.
It's just not in front of us, that's why I
Right.
was asking.
Yes.
So if it's not designated either by any of those processes,
Mhm.
then it's not a declared dangerous animal.
No, it's declared by the dog control officer.
Right, if they
after-
haven't done that, if they haven't declared that, I'm trying to get to putting someone in prison for a dog bite.
That's very rarely, to my knowledge, has ever happened, except the Aaron Ingram case, which was very bad. And that's typically when someone has been given notice, due process, has been told their dog is dangerous, allows to keep that dog, and they fail to comply, and then that dog injures someone else again.
Senator, I'm going to pause for just a second. I'm first on the agenda in Health and Human Services with a bill, and I begged him to hear it. I need to run up there. You're the secretary. You're the next ranking officer. Do you have a bill in HHS, or? Can you chair the meeting, please, and let me go to my meeting, or somebody chair it, because I'm fixing to leave.
Vote the bill out, Mr. Chairman. We can all go.
I'm sorry. Okay. Thank you. You got 2 questions. Yeah, thank you very much. You can use my gavel. Don't leave the gavel down.
Okay, we've got some questions. I don't know who was first.
Can I ask one more question to finish up? No,
If you make it quick.
On the insurance, and this is a question for the insurance, do we know of an insurance company that would insure a vicious dog? Does that happen very often? I mean,
Got a friend.
is that a common practice?
Come forward.
There are in the U.S. I know that.
Okay.
There
so
are.
That's
Absolutely.
a common practice.
Well, they actually specialize in it. So,
All right.
and not just one. There's several.
And one last question, canines, why do we exempt the canine? If a dog is a dog, why would you, is there?
It's not exempt. It's only exempt if it's an active duty of taking down a perpetrator or.
Gotcha.
Military, police.
Okay, Senator Harbison, or, yeah.
I just want to offer some support along with the bill and let them know that I think it's much needed. I had the unfortunate experience of having a constituent of mine viciously buy a vicious dog, and she was badly involved, put in the hospital for a month. I think she lost a limb, and they had this relationship with other parts of the body, elderly lady, and she barely survived. So I just want to, whatever. Now, don't get me wrong. I'm not a dog hater. As a matter of fact, I own a grand dog, so I
want to.
dog. Yeah, but yeah. So, but I think it's something that we need to pay attention to. I think this tries to address that, and I certainly would support that effort.
Thank you. Thank you, Dean.
Thank you, Senator Cowsert.
Thank you, Madam Chair. On lines starting 21 through 25, it's referencing if you have a dog that has attacked somebody else or killed another person's pet, and it uses the phrase an unjustified threat and kills a pet animal without justification. I'm curious to know what type of justification is there for, killing the neighbor's cat or attacking a person that puts them in harm. Are there justified reasons a dog should be allowed to kill other animals or attack people?
If that animal is threatening a person, the animal that's being attacked is threatening a person or property, that could raise the level of unjustified attacks. In other words, you asked if it's a justified attack. In some cases, a dog will protect its owner or property, and every case is going to be different. So there is some language in the current law about justification, and we use that actually in animal cruelty. I can't quote the actual law on it, but it does actually help us define what unjustified means.
So if they're protecting the home or their owner, or if you're messing with their food when they're eating, that just seems like it creates confusion.
Yeah.
Without further explaining what is justified as far as, threatening somebody. Doesn't even have to hurt them here, they just attack them. I just wondered, I've not seen that in the law before, but maybe it's from those other sections.
While you look at that, I'm going to move on to another question. Senator Lucas?
Isn't it true that most times dogs are pit bulls, Dobermans, German Shepherds, and usually they are very protective, especially German Shepherds and Dobermans. But when you start talking about 50,000, it's going to be hard for the insurance company to ensure that. Usually they will give you general liability on your homeowner's policy, which would cover that. But, you got to have a definition of a vicious dog. And most people call or use pit bulls as one. But as far as getting a $50,000 insurance policy, that's kind of inhelpful. In other words, I don't think you would find the insurance company that'll write it.
Some do, if they want to keep their dog. So right now, under the current law, you can have a dangerous classified dog that has bitten someone already and not have a requirement to ever have insurance. So that dog has bitten someone already, can go bite again, and there's no requirement on that owner to have insurance. There is only that requirement on a vicious dog, a dog that has done a serious injury. But a dog that has repeatedly bitten someone has been classified once. There's no requirement. The requirements are simple of what a responsible dog owner should do. It's to keep it on a leash and to keep it in a contained environment in your property. But there's no other real, incentive to do anything more than that. So if you look at what the current requirements are for a dog that's actually bitten someone, it's very minimal in Georgia. So what we're trying to do here is, if that dog has a known biter, has attacked someone, and it's classified, and we don't say you need to do more than just what a responsible dog owner would do, what if that dog bites again? And that victim there's no insurance, there's no money to pay for their bills. That's what this bill is trying to do.
Senator Anderson, did you come up with anything to answer Senator Kauser's question?
Senator Cowser, hold on just a second. Insurance, y'all want to say anything on that?
Yeah, which one of y'all gonna insure the dog?
On the, what, Senator Cowser?
This is what
Huh? Okay.
Senator Kauser, I think your question.
Give me just a second.
So this, without justification.
I think his question had to do with provoked, justifiable provoked. That was the question he was asking.
If, Senator Cowser, if you want to remove it, I'm fine with it. We'll remove it so you won't be confused.
I think it makes it easier for somebody to defend the case if they can say, my dog was justified in killing that squirrel or that cat, or biting that guy on the leg that's trying to break in my house. It's okay.
I like it. Okay.
I think it makes your job harder.
Well, if the squirrel's attacking your dog and the dog attacks it and kills it, that sounds justified.
That does? Okay.
Okay, any other questions from the committee? Senator Kennedy?
Thank you, Madam Chair. Senator, just a question. Looking at lines 73 and 4, and then also 83, as I read that under section 2B, if you do 1, 2, 3, and 4, then you can maintain the dog. And then number 4 says the owner provides proof of sterilization of the dog and microchipping of the dog. It's my
In the number.
Yes, sir. My question is, I'm wondering, what is the policy objective, or what's the thought behind the sterilization? Is it that you're trying to take this dog's genetic pattern out of the population, or are you trying to sterilize it to make it less aggressive, or is there some other aspect?
Less
I'm just
aggressive.
wondering. Okay.
About 76% of dog bites are usually from intact males.
Or from what?
Intact males.
Okay.
And then not too far underneath that are breeding females because of the hormones.
Okay. Thank you.
At least that's what the statistics say, and
I assumed that was the case. I just didn't know. Wanted to
CDC
make
has
sure.
some good statistics.
Thank you, Madam
Senator
Chair.
Robertson, did you have a question?
Yeah, just
We
very.
need to wrap this up. We're going to lose our room.
Yeah, just very quickly, I worked on this bill a couple of years ago and learned more about dogs than I'd ever known. In all seriousness, the meanest dog I ever had was a 5-pound deer-faced Chihuahua. And may Catfish rest in peace. He was very protective. But my concern is, as we were looking through this, our job up here is to perfect this, to make it sustainable when it gets to the courts where it'll absolutely get to. And it is so perplexing to me that every time we go through this, and President Pro Tem tried to help me out a couple of years ago on this, and it's just so slippery. But I did have the opportunity to meet a young man who came to my office with his father, and I'm going to talk about this without getting too angry. This young 4-year-old young boy, his daddy carried him down the street, and a pit bull came down and attacked the father and pulled the boy off of him and almost scalped the young child, pulled his scalp line all the way to the back. And this young kid has to go to school wearing a hat because of a huge keloid he has that's formed over his head, and doesn't understand why the other kids look at him like he's strange. And this is because of a absolute irresponsible dog and the failure of the community to manage the person that they knew had a dog that behaved like that. So I don't know. I think with a little bit of work, we can get it to where it needs to be. I don't think there's anybody on this committee that doesn't want to get it to where it needs to be, but I'm not sure that we still don't have work to do on this right now.
Well, since we're approaching the end of the time to get bills out of committee, then we need to make a decision what we're going to do. So I don't see any other questions. I don't see anybody else signed up. So what's the will of the committee?
I move to pass.
Is there a second?
I'll second to, and hopefully be able to sit
Get it, we can work on an amendment. We'll work on an amendment.
because Chairman Anderson's working on this for a long time.
And we've still got some opportunity. So with that, any further discussion?
Whip Robertson, could you elaborate on what more you want to see done on this bill? Because that may change some.
Well, I think as we walk through, I've got some issues with the definition of a dangerous dog. Senator Lucas brought up the point that there's a typical description of breed, and in here it takes those breed out. And I think some of the characteristics that are given that describe a vicious dog would fall into the category of the 5-pound Chihuahua I mentioned that I had when my wife and I first met. And I mean, he bit people, and in some situations there could have been a stitch needed, 2 or 3, because it was his nature. As small as they are, they're extremely aggressive dogs. And so I just think we need to tighten up some of those definitions, because I think we see this, and from the last piece of legislation we discussed in this committee, there's going to be some well-educated first barrister out there, attorney, if you will, who will dissect this language. So we need to make it as bulletproof as possible. And I've seen the effort that Chairman Anderson's put in and sat through long committee hearings on this same legislation last year, and I just think we need to tighten it up with the help of the attorneys that we have in our caucus.
So is it your intention to pass it today and then work on a floor sub? Or?
That's based on the time, and it would go to rules. And yes, sir.
Let me ask you. Could you basically put in there a dog who has bit somebody, and usually when they bite somebody, the kid has to get a rabies shot. But if they bite somebody and they notify animal control, then they can determine that the dog has bitten somebody out of character, and that on a next offense, they go to the pound and get killed.
And
what I'm saying is this. Pit bulls are known, not only to people, they're known to attack other dogs, period. Unless you make them docile. And you make them docile by spending time with them and not using them or treating them as vicious dogs. But I understand where he's coming from, because it is sad. I know of a lady that was walking, and the dogs bit her, and a neighbor had to go out and beat the dogs off the lady. And so I would say that if there is a dog bite somebody, you get a record of it. And to me, that says that either the dog has to be pinned up or controlled where he's not out or can get out. And outside of that, you just utilize it. You know, if you bite somebody again. But I mean, you got to look at dogs. They run with kids. You do something to the kid, dog jump on you for doing something to the kid.
Okay, Senator Anderson.
I'll work with anyone, anyhow, to come up with amendment or whatever on the floor, or, before we get the rules, the rules, and, to tweak the bill to where we need it.
I suggest you deal with Attorney Kennedy, Attorney Calvin, who's coming up, a way to do it.
Yeah,
There's a way to do it. It's
Cows and
just
dogs
how
that
you-
kill squirrels.
And I understand where he's coming from, because there have been folks who have been harmed by dogs.
So Senator Anderson, I think you're in a posture of, if you want to keep working on this, your options are getting limited, but I don't think there's going to be
I'd
another
like to go and
insurance
get it
committee.
If we can, any way possible, get it passed out, and then we'll work on it in rules, on amendments.
I so move.
Well, we've got a motion and a second, do pass. So unless there's more discussion, all in favor of the do pass motion, raise your hand. If you're in favor of the do pass motion, raise your hand. One.
I vote to get it out. I think it's a problem, and somehow we need to.
I'm supposed to get it to rules, but you can't work on it in rules unless you be committed.
To the committee.
Right, so if you're gonna do some kind of amendment to it on the floor, then you need to be prepared for that way before the floor back. I don't fully understand what you're gonna change on it, but I'm interested in hearing more about it.
I'll offer to the chair. Draw my second, if I knew there'd be another insurance meeting prior to the deadline, and it's her understanding that there will not be. And so,
I think it's today or never.
That's right.
yes, sir.
On this bill.
Yes, sir.
Yeah, if that's the idea, to quit to work on it here, are you saying within this committee, or
No, sir.
progress the rules?
No, it's going to have to be after we progress rules, because if I withdraw my second today, then it sits right here. And most likely it will be here next year, or it will have to be dropped again next year to get back here. Yes, sir.
But who made the motion to pay? I second the motion.
Okay, any further discussion?
And to be clear on that, just to keep that clear, Madam Chair, I will withdraw my second, and the second is made by Chairman Lucas.
Okay,
But we can work on it to try to get it, everybody understand what's going on.
And I would agree that it seemed to be working, no doubt about that, and I'm totally with
I think we got two capable lawyers, guys, thank you.
okay, so Senator Cowser,
Just on discussion, I'm gonna oppose your bill. I don't support dangerous dogs, but I don't think we ought to put people in jail for a year for failing to register a dog that's killed another animal or that's bit somebody or gotten out twice in a year, or they fail to buy that insurance. I don't think our jails need to be full of people with bad dogs. I think there's civil penalties to deter them, and I think the animal control system that we have in place adequately works.
okay, any further discussion? So we have a motion, do pass, and a second, and unless there's further discussion, did you have a question?
No, just in discussion, Madam Chair, just, Chair, I'd like to help move forward, and if this does, I'm happy to move forward. I'm afraid we find ourselves with a time crunch here, and we seem to be talking about issues, and probably the six of us all have six different ideas of how it needs to be tweaked a little bit. I tend to agree with you. I think something needs to be done. Some kind of bill needs to be passed, but based on the comments of Chairman Cowsert, it needs to be very different, I think, in that regard than what we have here. So I don't know. I'm torn. I want to be helpful, and if it moves forward, I'm happy to devote whatever resources I can to try to help come up with something that might be workable.
Well, let me say this. If the committee don't feel like we can get it straight by the time we get it on the floor by amendment, then I just ask you to withdraw your motions.
Okay,
We'll
so we'd have to withdraw the motion second.
We'll work on it next.
I think, excuse me, I think we can get it done. There's a way to get it done. We just have to put these intelligent minds together to get it done. I think there's a way to get it done because people have been bitten by a dog. And so I think there's a way we might be able to get it done. I think they might have to change some language in there as far as put somebody in jail and that kind of stuff, unless they operate on a dog fight lane.
Madam Chair, I call the question.
Go right ahead.
Call the question.
Okay. So at this point, we've still got a motion to pass, is that correct? And a second? So I think we've had enough discussion. All in favor of passing the bill, raise your hand. That's 5, and all opposed, that's 1. Okay, your bill moves forward, and I hope you can do some work on it. Thank you. Meeting is adjourned.
Madam Chairman.
Well,